In Yuen versus Li and another, Mr. Justice Cotter determined a contested application for security for costs. The claimant, resident in Thailand, alleged the first defendant misappropriated Bitcoin worth between 160 and 180 million pounds. The first defendant invoked Rule 25.27bi. Cotter J, applying principles from Porzolak versus Porzolak, held it was not just to order security. First, the claimant demonstrated a very high probability of success based on compelling evidence, including damning audio recordings, and the first defendant's bare denial. Second, the first defendant's costs estimate of £678,715.80 was demonstrably excessive and unsustainable, containing unrealistic figures for disclosure and preparation. Third, alternative security existed within the jurisdiction, via valuable watches seized by police and claimed by the claimant, with an estimated value exceeding £250,000. The court found no evidence of substantial enforcement obstacles in Thailand or Dubai, where the claimant held assets. Consequently, the application was dismissed in its entirety. Quote, "In my judgment, the claimant has demonstrated a very high probability of success. The evidence is that he was warned of what the first defendant was seeking to do. The transcripts are damning. And when the first defendant's property was searched, the necessary equipment to exfiltrate the Bitcoin was found. She has had numerous opportunities to give her side of the story, but has declined to do so. That the Bitcoin has remained at the addresses to which it was moved is consistent with the problems with realizing its value, problems which the first defendant herself, on the claimant's case, identified in the recorded conversations. 24 years as a first instance judge have repeatedly highlighted the wisdom of applying Occam's razor. That the second defendant was involved with the first defendant will provide no defense for her."
For a detailed summary of this decision, visit tmclegal.co.uk.